Disclaimer. Later in this video, I was discussing local rules, but for some reason, I kept saying legislative rules. I'm not sure why I kept getting that mixed up, but it is about local rules and not legislative rules when we discuss Ada County. Okay, there was a couple documents that came out yesterday after Judge Hippler denied the motions to strike the death penalty. And I've seen some people misinterpreting one of them. And I've seen people saying that Bill Thompson's being petty when talking about the other motion. So we are going to take a look at those. So this first one is the amended petition for appointment of special assistant attorney generals. So this is to amend the appointment that came out in April of 2023. Okay, so this was the original from April 24th of 2023, and it was when he petitioned the court to allow Jeff Nye and Ingrid Beatty to help with the prosecution. So they were being basically loaned to him from the Attorney General's office. And what he put out yesterday was an amendment to that motion. But before we read over the document, I want to show you what one person in particular is saying that it means. And there have been a few other people that are also claiming that it means that Bill Thompson is asking for additional help, which is not the case. But let's listen.
So he's putting in the little statement, it's prospective duration. Well, when he was granted the special assistance of these attorney generals, that was April 24th, 2023. This trial is going to happen less than a year and a half after that date.
Wait, what? August of 2025 is less than a year and a half after April of 2023? Homeboy, you ain't good at math. Let's continue.
You can bet there is nobody that assumed that the trial would happen that fast. So for him to cite prospective duration like it's taken longer than it should have as reason to change his counsel is disingenuous on his part at the very least. But the true reason you can see is what he states first, the nature of this case. So what he's saying is the nature of this case demands stronger counsel to prosecute it. And I petitioned this court to amend the appointment filed herein on April 24, 2023, to appoint the chief of the criminal law division or his designee as a special assistant attorneys general to assist in the prosecution of State versus Koberger, so as to facilitate the prospective transition of assigned deputy attorney general as may be appropriate. So either Nye, Beatty, or both have said there is something very wrong due to the recent filings by the defense in the motions to suppress, or they said this is way over our head. It's one of the two. So he is requesting, he's really requesting not just another attorney's general, but the chief of the criminal law division. I mean, he's saying that he wants as big a gun as he can because this thing is getting out of his control.
Oh, so it's getting out of his control and he's wanting the big guns. Hey, boys and girls, can you tell me who the chief of the criminal law division is in Idaho? Take a guess. 3, 2, 1. If you guess Jeff Nye, you are correct. Yep, it looks like Bill already has the big gun, because outside of the Attorney General, Raul Labrador, Jeff's the big gun. He is the chief of the criminal law division in the Idaho Attorney General's office. Sorry, Pav. Guess you were wrong about this one.
That tells me that the motions the defense just filed have this Santa Claus figure puckered up.
Yeah, I wouldn't bet on that. So let's go through the amended motion and we can see what it's actually talking about. Okay, so it says amended petition for appointment of special assistant attorney generals. And this language, a lot of it is basically the same as the original petition. So Bill is saying he's the duly elected Latah County prosecuting attorney. He has the duty to prosecute all felony criminal actions committed in Latah County pursuant to Idaho Code 312604 as prosecuting attorney. I have sought assistance in this case in order to utilize the expertise and additional resources of the Attorney General Office. The Attorney General's Office has agreed in writing to assist the Latah County Prosecuting Attorney's Office in this matter. Pursuant to the written agreement, the Attorney General's Office agreed to pay the salaries of its personnel who assist in the prosecution. And then on the next page, it says the nature of this case and its prospective duration may require the transition of assigned deputy attorney general to meet staffing needs. Deputy attorneys general to meet staffing needs. I underline that because that's important. I petition this court to amend the appointment filed herein on April 24, 2023 to appoint the chief of the criminal law division, that's Jeff Nye, or his designee as a special assistant attorney general to assist in the prosecution of State versus Koberger, case number CR0124316665, so as to facilitate the prospective transition of assigned deputy attorneys generals as may be appropriate. So, as may be appropriate is key, along with staffing needs. Okay, so what does that mean? Does that mean he's asking for additional help? No. Does it mean he's asking for the big guns? No, because he already has Jeff Nye. He has the chief of the criminal law division. What he's asking for is to make sure that Jeff Nye or a designee that Jeff were to choose stays on the case and is there to help transition if another person has to come on because Ingrid, because she's the other person from the Attorney General's office, were to be switched out due to staffing needs. So what just happened in November? We had an election, okay? Even year election. So state legislatures were elected and reelected. Some senators as well. And I'm not talking federal, I'm talking state. After they get sworn in, they go into session. January, February. One of the things they do during the new session is they decide the budget. Budget goes into effect fiscal year. So July 1st of 2025, the new budget for the state of Idaho will go into effect. When's the trial taking place? August. So, any budget cuts or changes to staffing levels could affect the trial. So Bill is being preemptive, anticipating there could be some staffing changes in the Attorney General's office, and he's wanting to make sure that he's still approved for that staffing and to have at least Jeff Nye on the team, and that Jeff is who would be in charge of transitioning someone new if Ingrid were to have to be pulled off the case. And you have to remember that there's not just the Koberger case, there's also Skylar Mead, which is a death penalty case, and it looks like Nicholas Umfenauer is going to be. So you could possibly have 3 death penalty cases going on next year. Also new budgets for all of the state offices. So this is no different than when Anne had the ex parte meeting with the judge to make sure her resource judge was still going to be in place and her budget was going to be okay for all of her experts and her staff and everybody so she could continue on the case. This is Bill just being preemptive in case staffing shakeups happen. So he's doing his due diligence. So this has nothing to do with him being scared about any documents that Anne filed. He's not puckering up. He's not asking for any more assistant attorney generals to help. He's not asking for the big guns because he already has one of the big guns. It's just being preemptive in case something happens with the budget or people getting stretched thin in the attorney general's office. And you'll see that Judge Hippler approved the motion. So it says it is hereby ordered pursuant to Idaho Code 31-2603B and 67-14017 that Deputy Attorney General Jeff Nye and any other Deputy Attorney General selected by the Attorney General's office be appointed as special Attorney Generals to assist with the prosecution of this case. Okay, so now this next one is where people are saying Bill's being petty, that he's being petty Crocker, and because he's filed a motion to basically negate Ann's memorandums about the genetic information and the Franks hearing. So let's take a look. Okay, so it says, motion to strike defendant's memorandum in support of motion to suppress regarding genetic information and memorandum in support of a Franks hearing. So it says, come now, the state of Idaho, by and through the Latah County prosecuting attorney, and moves to strike defendant's memorandum in support of motion to suppress regarding genetic information and memorandum in support of a Franks hearing because they violate the local rules of the 4th Judicial District. Memoranda in support of non-dispositive motions must not exceed 15 pages. Legislative Rule 8.1. Defendant violated this rule when he filed a 37-page memorandum to support his motion to suppress genetic information and a 33-page memorandum in support of his motion for a Franks hearing without seeking leave of this court. Legislative Rule 8.3 explains page limitations in excess of those set forth in Rule 8.1 requires prior leave of the court. A memorandum in support is not being filed with this motion as the state believes page limitations qualify as a routine matter. See Legislative Rule 8.1. The state requests that the court decide this issue without a hearing. See Legislative Rule 5.3. Okay, so is Bill being petty? Or is he just following Ada County legislative rules? But before we look at those legislative rules, let's look at the definition of a non-dispositive motion. Non-dispositive motions are legal requests made to a court that do not seek to resolve the case entirely, but rather address specific issues within the case. These motions can help clarify procedural matters, obtain necessary information, or request temporary relief while the case is ongoing. They often involve requests such as motions for discovery, motions to compel, or motions for summary judgment on limited issues. So the different districts' legislative rules can be found on the isc.idaho.gov website, and you'll see all the different judicial districts. So I clicked on the 4th Judicial District for Ada County, and you can see the last time this was updated was in 2021. And I've highlighted all of the important things that show that this order has been approved and adopted. These amendment local rules became effective immediately. They have been sent to the Judicial District for publication and dissemination, and they were also included in the State Bar Desk Book. And here's where you'll find 8.1 and 8.3, and we'll take a closer look at those. So 8.1 under motion practice says each motion other than a routine or uncontested matter must be accompanied by a separate memorandum or brief that must not exceed 15 pages. For summary judgment or other dispositive motions, the supporting memorandum or brief must not exceed 25 pages. And then if you go down to 8.3, at the bottom of it, it talks about the page limitations for rules 8.1 through 8.3. So it says page limitations in excess of those set forth in rules 8.1 to 8.3 requires prior leave of court. So Anne did not get a prior leave of court, so she did not put in a motion for leave. That would be to vary from the traditional rules. And she did not follow the Ada County legislative rules because those memorandums had more pages than were allowed by the legislative rules. So Bill is not being petty. He's doing his job. Just like how Anne is doing her job, pulling out all the stops to defend Koberger, Bill is doing his job as the person representing the taxpayers, the citizens of the state of Idaho. So it's his job to also do everything he can, and that includes making sure Anne's following the laws, just like Anne's trying to make sure, that she's making sure Bill's following the laws. He's trying to make sure she's following the laws. So this isn't being petty. Those legislative rules were approved. They're on the book. They're published with the state bar. She should have known. Even if Latah County has different rules, even if Kootenai County, where she practices most of the time, has different rules, once the change of venue happened, she should have looked up the legislative rules for that district. And it's also not that much different than federal law. Let's take a look at federal criminal code. So this is from WEX, from the Legal Information Institute, and talks about non-dispositive motions. And I'm going to go to the next section where it talks about the page limits. And it says, no motion subject to this section, together with the brief in support of the motion, so that's the memorandum, or brief in response to the motion, may exceed 15 pages in length. Now, it does say on the federal one, exclusive of pages containing the table of contents, table of authorities, and any addendum that consists solely of copies of applicable cases, pertinent legislative provisions, or rules and exhibits. No reply brief may exceed 6 pages in length, and then it's also exclusive of those things. Okay, so even federal guidelines have a page limit. So all Ada County did was adopted those. Anne should have known. And at least like Elisa Massoff, I know, has tried cases there in Ada County, defended cases, so she should have known. Certainly one of them should have looked that up after the change of venue, and they should have asked for the motion for leave to have a longer amount of pages. So I don't find this bill being petty at all. He's doing what he needs to do, and that is the law there in Ada County. So it'll be interesting to see what Judge Hippler decides on those two memorandums. So let me know if you have any questions and if there's something else you want me to go over.